practices perspective. And I'll be covering 4 sectors for this session, which are more tangible in a sense in an Indian context, which will show that what the impact is there. So of course, one is of course around health tech. Then second is fintech. Third is e-commerce, and the last one is legal tech. And I'll try to see if I would have time to discuss a little bit about implications of other regulations, but I think most largely I will cover sector focus, and because there will be a lot of concepts which will be revolving around. So it will be about contracts, it will be about consent systems, it will be about data minimization aspects, right? And uh, that's how we need to understand. So it will be a basic understanding thing, but I'll try to give some hypothetical case studies so that we try to self-reflect on these questions, because again, the law is not yet enforced properly. We don't have specific rules for specific sectors, or even from a sector neutral perspective, like a basic understanding on certain questions. So at least a starter point would be great to go ahead. Right. So let's do that. So yeah, first part, I'll quickly discuss AI policy landscape in India, what has been the situation, how it has been with the DPDPA, what's the story all around. So I'll take the first 5 minutes or 2 to 3 minutes discussing this. Let's say, so this is a basic summary. There was a data protection bill which was proposed in 2019. Then there was a Sri Krishna committee, I think in 2018 or 2019, which had also proposed something. Discussions have been happening between MNCs, technology industry associations, and government of India, and even citizens through public comments. Uh, the last DPDPB, as we know, under the Ministry of Electronics and Information Technology, had around 88 sections or something, and it was scrapped. And that's why now we have some 30 plus sections, which are certain basic provisions, and a lot of sections are there, or a lot of parts are there in the bill. Sorry, the draft act, which is now passed, a proper act in the parliament and assented by the president, which shows that a lot of it says as prescribed by law, which means that a lot of it is still not decided yet. So that's definitely the thing there. Then Niti Aayog, which is the government of India's key policy think tank and advisory body, a successor to the planning commission, they had developed a national strategy for AI for India, which was more about building an AI garage. It was more about capabilities, what could we invest, what could we not, what are the certain ethical aspects. They also came up with a 2021 responsible AI for all paper, in which they had addressed certain issues around facial recognition technology, judicial processes, and Western biases around AI ethics. Like why should we follow just some European or American ideas? They had discussed that. So that's the Niti Aayog strategy. But that shows you that there is some understanding of AI policy which the government wanted to have, and that's the thing which you should know. Then an AI advisory had come up after the IT rules of 2021. And what happened was that that the elections were happening, so a lot issue was about misinformation, where deep fakes, another form of synthetic content, was being created. So the problem was that the government was feeling, we should try to regulate it in a way which makes sense, and as it is regulated effectively, we should ensure that the regulation at least curbs the impact of deep fakes when it comes to election integrity. And again, election integrity is an interesting problem of our public interest, even in the Representation of People Act. Now, so Rule 31B of the IT rules of 2021 were invoked, initially saying that, all AI models will be covered. They have to go through a registry process or affirmation process to METI. And, well, that was not taken in the sense of positive sense by the AI community, because it was very arbitrary. And the second problem was there was no public copy. So we never knew that, the METI had a public copy of the advisory. It was just some person in a cyber group, a certain other aspect, using third-party sources. Somehow a lot of us came to know about the draft, advisory, which was a proper advisory. And then in March 15, they scrapped that part stating that, all systems are under this and blah, blah, because it was a lack of clarity. Like, it's fine to regulate misinformation, but then what exactly is public and not, and how do you do it? These are very nuanced questions in media law and technology law, which they did not address. That's why they just focused on deep fakes and specific changes that maybe you should have certain mechanisms like a pop-up window or something, but that again is not a proper solution because that's just a technology adjustment according to them. So that's why the advisory was not a successful experiment. Still, it still exists. It's not binding. It does not have any impact. It just exists because they sent it to a set of companies. But the problem is when you say you're sending it to a set of company, why are you saying all of them? You mean all of those companies, or do you mean all of Indian companies? So will it also affect somebody who is building an AI model or a machine learning algorithm in engineering colleges? I don't know. So that was a very hazy territory out there. Then a special committee of legal specialists were created uh, to propose a digital competition bill to the Ministry of Corporate Affairs. That was also in the process, that was already happening. And now, as we know, as Business Standard and a few outlets have reported, that a draft law on deepfake regulation is already underway for 6 months. They will draft something. Majorly, it will cover deepfakes, which is again not that hard to recognize in a legal sense. The challenge is about what technology tools do you need to cover deepfakes, and what forensic methods do you need under criminal law and civil law, and how will you decide a quantum, who will be the companies doing it properly, how will you support such an ecosystem which actually makes it happen. So that's the thing, and the law needs to be simple on that. So that's the AI landscape for now. And so overall, I'll give you a basic understanding before we move into DPDPA quickly. uh, so as I've been talking about this, the one thing which we need to know is that right now the AI policy approach which we have in India is a bit skewed in a sense, right? I gave you an overview of the AI advisory, I gave you an overview of the AI approach. What is the problem is right now that maybe because of a lot of summits happening on AI policy, whether it is a Seoul summit, Seoul summit have happened after the advisory, or uh, and whatever happened before, like the Bletchley summit, okay, or the GPAI summit, of which India was the chair in New Delhi this year in just December 2023. A lot of things happened, and we kind of got panicked from a government's end. And that's why what happened was that they came up with an advisory, things like it might work, but they did not care about the wording, and every wording matters. How do you interpret it? How can you enforce it, like, properly? Can you go to a court or not? Because again, a lot of it's at stake, because a lot of AI startups and even AI MSMEs or people who are working on AI in research labs, they're still at a stage where you can't say that AI properly is productized. And due to the hype around generative AI, where there are some genuine Gen AI use cases, there are some hyped up use cases, like somebody just buying a .ai domain and saying I've built a Gen AI, turning out it's just a CSV file with a website connected with some API, headless authentication, right? So like even such stuff happens, and people fall for it at a consumer mass level. And unfortunately, sometimes even bureaucrats and judges may fall for it. Sadly, that's the case. We can't deny the fact. So lack of awareness is a huge issue in India, which is to say digital literacy and other things around how AI works. So Gen AI obviously involves a lot of productivity tools, so I'll not get into that. But on a specific note, I'll get into what should you know about the DPDPA right now. There are too many things in the DPDPA, but for the sake of the session, since I'll discuss sector-specific implications and there will be some miscellaneous parts, these are the 5 things you need to know first for a basic understanding. First is about that this law is very clear in certain aspects at a beginning. I mean, a lot of it's to be prescribed. At a very functional level, it says that data collection processing techniques matter. How do you do it? You have to explain it to the end user or end business user. It doesn't say end business user, but everyone is covered, because the definition of a person includes companies and institutions in the DPDPA is section 2. So of course it covers everything, and even in a consumer commercial law context, end users include everyone. So any end user it is, there are certain techniques. What do you need to do? You need to be clear about it. I'll discuss that in detail. Second is purpose limitation. Why are you processing the data? Now in the case of AI, it's a very interesting challenge, because you have to define the limits of why will you process something, and how is it correlative to your own use case or test case or whatever, and how much you define your purpose limitation, so that the person whose data are you taking is aware of the fact. So that's a dilemma to address through. And yeah, I'll be addressing all the Q&As in the chat, maybe in the end of the session, at the end of the session, as we've discussed. So that we'll do. But yeah, I appreciate the questions which are coming up. So third one is data minimization, same under section 5, that, why do you wish to minimize the use of data, in what ways? Then we have cross-border data transfers. So for example, you are, transferring Indian data, or Indian citizen owned data, or Indian end user owned data. to any other country, which countries are permitted, and that's a negative connotation in certain sense, right? Unless it is restricted. Of course, you can't share it to certain countries which we know, which we with which we have national security issues. I don't need to tell which countries which they are. So yeah, obviously that's the thing which we all know. So that's a very basic of basic requirement which every country has. The European Union has it in the case of Russia and others. The Chinese have it in the case of others. That what, you can't sell it to others and all that. So there are basic restrictions to the government. Again, nuances are required. And the last one I will discuss before obviously we go to specific sectors like health, education. Sorry, not health, fintech, legal, and e-commerce is transparency, explainability. Like there are certain rights that you need to know in sections 11 to 15. But I focused on explainability rights. So they are kind of similar to the GDPR in certain ways, but a lot of GDPR is still not here. So I'll discuss about certain nuances, how a bureaucrat must have thought about DPDPA while drafting it in certain ways, because I'll tell you that, but let me go to specific slides to tell you that. So let's do this. All right, so we are now at this one, data collection and processing, sections 4, 5, and 7. Now, very basic aspect, you need consent from whom you are taking the data, which is to say your customer, citizen, end user, end business user. Here we say data principal, which would say individuals. And it works in the context of personal data, very specifically. And it says that, before collecting something, you need explicit consent, and you need it in certain ways. Now, I'll discuss sector-specific implications, how it becomes complicated and messy in so many ways, but that's the basic understanding. Then again, data collection should be limited to what is necessary, which is a purpose limitation principle. If you're processing for something, you need to specify the specific purpose. And merely stating in a privacy policy will not work, or merely stating in a terms of use doesn't work. Why? Because the problem is, I'll tell you, a lot of MNCs, including Google and all, they are, even OpenAI, they have this problem that they have a lot of community guidelines and policies and bylaws, okay? But for an end user, it just becomes difficult to go through all these pages, web pages, even not even PDFs, I'm talking about web pages, and scrape through and understand, okay, fine, you're saying this exact policy applies. So again, fine, you can draft in a legal way like a lawyer for you does, but then you have to also make it accessible to a person who is, and again, with MNCs, it's a different issue. So I'll just keep at that. And if you are using data in that way, you should have some legitimate use case or a legitimate purpose. Why are you doing it? And I'll discuss that also in this presentation. So let me go next. So these are the legitimate use. First is obviously somebody saying, okay, fine, I'm giving you consent. You can use my data in this way. And, the person knows and, it's done in a same way. So yeah. Second aspect is very basic, which is public interest in emergencies. For example, some disaster has happened or a health pandemic is there and all that. So that's obviously an issue. If it's a concern that, there are certain problems and that could be, under the Disaster Management Act, you can, of course, process data. That is something which is permitted as a legitimate use. Then, for example, it's a contractual matter where a court order kind of, says that, yes, you can do this legitimate use, you can process data. A court order permits you to do that. Maybe in the case of a government PSU, or maybe in the case of a private sector company, which depends. Or a PPP model, depends how it is standing in a court, a civil court, or a high court, or a Supreme Court. Yes, complying with the court order also means you can process data if you comply with the court order. And the last one is for the performance by the state or any of its instrumentalities. I directly took it from the act because I wanted to show you how it is, which is to say that how a government does, you need, say there are certain instrumentalities when it comes to matter of sovereignty and national security for a government. Again, I think that might need some clarification. That depends, but that's another thing for a debate that that is something which depends on when the government replies or when the government clarifies. Maybe this part might not be implemented or what, we don't know, because I can just tell you a new Telecom Act was just implemented, but only parts of it were implemented, not all parts of it. And that was notified in the official gazette just a few days ago, maybe just yesterday if I'm right. So yeah. And this is also an important legitimate use which people in the PM side, product management, and data science people should know, and even people who have businesses, they should know that there are certain aspects of legitimate use when it comes to employment contracts. You can actually process an employee's personal data without specific consent, but for certain reasons. For example, if there's a risk of your trade secrets, which are confidential, which could be leaked or disclosed in a way that you don't want to, and that's within your rights. Of course, how have you taken that data? That depends on the employment agreement. When you hire somebody or an intern or whosoever, that's a different matter. But of course, when you have the data, you need to protect it. So legitimate use to process to ensure that corporate espionage and other things are avoided, you can do that. So these are the basic things you can see. I've not discussed the employee part in this because again, it's more about AI products and solutions. But I thought, this is just a touch base for all of you. Then we have a purpose limitation principle. I've already talked about it a little bit. It's just a reiteration that you have to be specific on a purpose. But for LLMs and even in general, when you're using third-party applications, purpose limitation principle is a very tricky territory. What are the basic understandings? What could be a basic SOP that you can follow? How can you ensure that it happens in a sensitized way without any problems? That is a issue which requires addressing. So that's definitely out there. And data minimization is also the thing. How much data you should use, what is the irrelevant part you should not use. You should make it clear, and that is something which also could be a challenge, especially in e-commerce and fintech, where a lot of business models are around the models like UPI and others. So of course that's a very interesting challenge to look forward to, at least from my end, to understand from a legal perspective. And yes, that's the whole thing about data minimization. Transparency, explainability, it's more like, okay, and this is a problem which a lot of Gen AI companies and AI companies have this, that their models need to explain why are they processing something like this. Now, if some model is stochastic or probabilistic, if it is, that depends. If it is, now in the case of LLMs, a lot what happens is that they are not exactly stochastic in certain ways because they do a lot of data scraping. Because I am like a regular user of Claude 3.5 Sonnet and all these things. I use Perplexity. I'm a fan of Perplexity. I think they're better than OpenAI. That's my personal opinion. Again, I'm not promoting them. I'm not promoting Arvind Srinivas. But I think that even Perplexity and ChatGPT and all these tools, they have this problem that there are certain set patterns within which they process and do things, and a lack of explainability could always be an issue for them. So that is something which is a dilemma to address. So of course, that is the thing there. So yeah, that is definitely there. And yes, therefore, somebody whose information is being processed, they should have the right to access information, how their data is being used. They should know. And I think consent management is also coming here, right? Like, for example, you're giving prompts so many times. How are you ensuring as a company that, you're not manipulating a user's consent in terms of how many replies you are getting and how they're asking questions? Because pen testing is a thing, it happens. And again, there are ways to counter pen testing, of course, but then again, it depends. So I think Anthropic is one company which is working on a very interesting approach to this as opposed to other companies. So that's my understanding. Then these are just some basic rights like, and this is about purpose limitation and specific purpose, that uh, the DPDPA gives a consumer a right, a citizen a right, a user a right, that they can withdraw their consent from processing data, especially personal data, in certain aspects. And right to correction is there, that which is right to be forgotten from the European Union, the very great GDPR, which is a success in many ways. Uh, so yeah, right to correction and erasure of personal data. Then right to nominate another individual to exercise rights, and that is a basic thing in Indian law that happens. My kin or my person who I give power of attorney can do so if I am not capacitated to exercise my rights. That's a basic thing in Indian law that happens in the case of marriages, that happens in the case of property law. So yeah, data protection is civil law plus public law, so that's obvious to have this section 14. So that's a very interesting dilemma. And this is also an interesting one, which is cross-border data transfers. I've already said that if you're processing, sending your data otherwise, and how, because that's the same would happen in the case of GDPR as well. If you're processing European citizens' data, which is EU citizen data, you are going to have to comply with GDPR, right? Because a lot of firms in India, I know that they kind of process EU data. So obviously, that's a thing which could be naturally expected. It could apply even in the case of California or other US states among the 51 states, as we know. So that's also an interesting question. What could be processed? It could also help in research aspects. For example, research collaborations could happen in an ethical way, in a contractual way, and that could also be because I can tell you that data connectivity agreements are trying to be happening between European Union and India. So that's already in the process. Now let's discuss the DPDPA from a data practices perspective. I think that would be interesting to look through. Uh, when we look at it, I'll be giving a basic understanding of what could be the possible compliance challenges and compliance strategies at a basic level, because now, since I've discussed certain important features and I've not discussed contracts and those things yet, because I'll do, we will be delving into sector specific issues. So I think we'll delve into that quickly and then we'll see what could be helpful for everyone. So these are the compliance challenges. The compliance challenges are about data minimization. As I said, the AI systems will require large data sets. How will you balance the need? What exactly do you need? And again, a lot of companies also try to have these agreements, right? I take some of your data, you take some of my data, and we have an arrangement so that we process in a way that is good for both our interests. So, and we have to remember one more thing. If you have a separate entity doing data processing, they are not obliged as a data fiduciary under the DPDPA. So you have to have contracts specifying dispute resolution clauses and other things, saying that if you're processing this data, you have to admit in writing in this contract that you will abide by these particular things, so that we also comply with the DPDPA. And if because of you as a data processing entity there have been some fallout, then there has to be some particular backup measures which have to be stated in a contract, that compensation will be there or something else will be there. So that is a very important thing, because this law, because generally data protection regulations also apply to data processors, but in this case it doesn't. So whether a data processing entity is a fiduciary or not is a different question. Of course, if you're both, then of course automatically you're a fiduciary. You are not going to do a contract with yourself. The best you can have is your bylaws or regulations within your own company. That's the best you can do as a part of your internal practices. But obviously, so that's one important thing people need to know. Consent management is also a very interesting thing, especially in the case of what kind of dark patterns could emerge. Like in consumer law, certain rules have been drafted on dark patterns, and negotiations are still going on. People are trying to understand. Firms and companies are talking to the government, the consumer ministry, specifically consumer affairs ministry. So consent management is also interesting, because in e-commerce and fintech particularly, you will have a situation where you will be sharing certain things, and you will be making a user go through a set of pages or points of interaction where you might incentivize a user for certain transactions or things. But how are you ensuring that the user is consenting to go through? Because now a privacy policy alone won't help you, right? So older days you just used to have a privacy policy, everything was written fine. If person has read it or not, if you are using a platform, a person automatically agrees to the terms and conditions, etc. But whether will this work? No. So yeah, consent management is an interesting thing. There are some techniques and things being worked out, and this is under the talks across places in India. And yes, third one is also interesting, right to be forgotten. So for example, you have to erase some data, and how will you do it? Obviously you can do it, that's not a problem, but will it affect your own models when it comes to your businesses and other things, your own internal practices? Because at the end of the day, you have to decide and think what is workable for a lot of people. So that is also an important dilemma to address. Data accuracy. This is also an important question, that ensuring and maintaining the accuracy of data is itself very important, because data quality itself is necessary sometimes from a sector specific context. Sometimes there are aggregation principles, like we have aggregators in fintech, but how will you maintain that? Again, I think it will affect a lot of large scale models who actually have an explainability problem, that lack of explainability affects them. So I think compliance challenges include these. uh, because after these and the strategies, I'll directly go into sectors, and I'll address the hypothetical case study quickly. uh, Compliance challenges, if you look at it, the last two, of course, explainability, I've discussed that. Now a problem with AI models, and a lot of you who are aware about AI will know that, and those even who don't know, uh, AI models can process something, give you an output, do certain things as you wish to, but they can't explain why did they do so. Now, in certain cases, they can be stochastic. They're learning, right? In certain cases, they are not. Certain, because a lot of LLMs are useful as productivity tools despite their flaws and despite their incorrect responses, is because certain patterns are already set in a predefined manner, and that is something which companies are working on, even at the level of perplexity OpenAI. That's not deniable. That's just common sense. So they're not exactly stochastic anymore. They are more, I mean, there are some aspects which they're doing uniquely, but a lot of it is deterministic in certain ways. So that's an interesting thing with large language models, not with every AI, only with generative AI I'm talking about. So that's the thing. So of course that's an interesting dilemma to address, and making it explain it to someone in the government also. And obviously cross-border data transfers, I don't need to reiterate on that much. So there are some strategies we can discuss about, but I think I'll address them specifically in the case studies, sector wise, as I think that's a concluding part before we go on with the Q&A. I think the Q&As are going to be more interesting. Uh, if you're starting something out, or you already understand your data governance approach in your own company or wherever you are, you need to be thorough about how data is being processed, which third party entities are you availing, which API are you using, where it is going. You have to have a sense of clarity. Maybe then you can have some privacy by design features that you can ensure that you can minimize certain things. And that's a very crucial business decision, because I understand that it's a dilemma for people. Data mapping is definitely a thing that is keeping a comprehensive record, so that you define a table as to why are you doing something, like a to-do list or a not to-do list. uh, that is a very important dilemma. uh, Advanced consent mechanisms is the same thing as I said, so I think I'll discuss more in the sector side. uh, and again, same about erasure, same about explainability, same about audits will happen when uh, you are doing impact assessments, because under the DPDPA, your company will need a data protection officer who will be overseeing all these things around. It could be even the CEO, or I don't know, managing director, or whosoever it is, but it could be anyone, right? You can have a separate DPO who can handle all of this. So I think this is a business to business problem, how they address, how their practices are. And localization, I'll a little bit discuss before I get to health tech and others. Localization is interesting when you have partnerships with data centers, and if necessary, and if you see that, okay, uh, how are you localizing or pseudonymizing some part of data, so that uh, when you're doing cross-border data transfer, you are ensuring that the data is not being de-anonymized. And that is something also being addressed in the case of generative AI in healthcare. In the case of because it's happening, a discussion is happening how to use the potential of India stack, which is your Aadhaar, DigiLocker, and all that, with Gen AI models. Now, in the health aspect, the National Health Authority in the government of India is already thinking about it, the NHA. Again, there will be privacy issues, there will be some dilemmas, and that needs to be known. So, yeah. So now let's talk about the thing of the day for which we all are here. Uh, uh, sure. So I'll address the questions later in the chat. Um okay. So the first sector we're going to deal with is going to be e-commerce. Uh, so e-commerce, I'll be very specific on consent. When you say consent, uh, uh, in the case of consent, uh, of course you need unambiguous consent, right? You need to know that if you're showing an offer or something like that, or you're showing a thing, when you're having affiliate marketers doing your thing in the platform, how can you make it unambiguous for people? And that is a very important dilemma to deal with. How can you ensure that your consent requests are simple? And again, another dilemma has come up. Now you can't just do it in English, you have to do it in also other languages under the various schedules, under the eighth schedule of the Indian Constitution. Uh, Enforcing that other part, again, maybe certain technological interventions can be done, which are making things translatable or something like that. That is again a technology feature which could be included to comply with, and that itself is an interesting thing if can be tried with. uh, of course, it will increase the task of people in the UI, UX, and app development side, but yeah, it is what it is. Uh, Again, and another aspect is pre-checked consent boxes and bundled consent. So I'll give you a very interesting example. So the Ministry of Information and Broadcasting, they came up with a simple guideline based on the Supreme Court's order that advertisers, whether in mass media, which is to say TV, radio, the traditional ones, and online, like Instagram ads, Facebook ads, Twitter ad, X ad, or LinkedIn ad, you have to sign a self-declaration to the government of India's ministry on their website by registering as an advertiser. Now, it means that if you are a personal individual who is just an influencer or somebody who has having a startup or a foundation, whatever you have, if you are using ads, you have to do it every time you post an ad. Now, what happened was this portal was opened, and again, this portal has a lot of glitches, like a lot of government portals have, unfortunately, like the income tax portal and all that. I don't need to talk about it. And second, in principle, it looks good. I mean, you should have a self-declaration, ethics declaration that whatever you're posting, and it should not be intrusive, right? In ad tech, that's a question being addressed that ads can be misleading for people. But the problem is, uh, it's not being understood that this is a very traditional way and it doesn't apply in the age of internet. How many times you're posting an ad, in what contexts are you doing it, how can you properly accommodate things in a way that you get an audit of specific advertisers technically who are posting something like an ad, right? Now, can you do it through intermediaries, like if Meta posts an ad for you, can you ask Meta to get information who are the advertisers who have done it at this particular timestamp? Can you do that? Maybe that could be a technological intervention, and then you can ensure that the concerned because you have these tag IDs and everything. You have enough metadata and ad tech to ensure who's the advertising entity. So anyone could be an advertiser. You just have some $500 or $5,000 with GST, put it on Facebook or X, you can post it. So it's an interesting dilemma. These traditional approaches don't work in the case of the internet age. And I think, that's why I told you that pre-checked boxes are a good idea. That's why consent matters. But pre-checked boxes and bundled consent, how will certain practices be standardized? That's a very interesting dilemma. Okay, let's quickly then go to other aspects. Okay, yeah, just a second. Okay, yeah, stringent data processing principles. Same things as I said. Minimization is an issue. Uh, if personal data is erased, what's the aspect of retention? Why are you retaining it for a certain time? That is also a problem. Can you retain it for 30 days? And if you're doing it, why are you doing it, right? Because at a product management level and otherwise, you also will decide, okay, I might try for such pilot projects which could help my business or other business, whosoever we are, and that's fine. That's your business decision. Nobody is doing wrong with that. But you have to keep it specified in a way, and that's also a dilemma to deal with. Okay, then we have expanded rights. Again, the same thing. And as I said, you need data protection officers in your companies who actually handle these matters, who actually deal through in person, so that you know uh, because a good registry of this is needed across the years or across the months, so that uh, you're complying enough. And a lot of things again have to be made more clear sector wise, because again, right now the problem is we don't have the rules. And I am telling you certain basic things which you need to know, but I think this will become more interesting once I address the case studies. And there are certain self-reflective questions you can ask that on the chat. It will become more interesting. So let's get on. uh, this is the same thing for e-commerce. If you are, for example, doing some e-commerce for foreign entities, which happens in India, where your users are from outside or otherwise, uh, data handling practices matter a lot. So that is, of course, an important dilemma. So these are the key takeaways. Uh, when it comes to the PPT itself, the deck, I think, yeah, I can share it with the organizers if they're fine by it. I have no issues. That will be done. Uh, but these are the basic things which can be started with, because a lot of sensitization at an employee level is needed. Basic sensitization at a customer level to gain trust is needed. And once within a timeline, certain practices are adjusted in the timeline, I think it becomes simpler for people to go through. Because I think uh, there will be certain things which will be open for explanation, but that's the basic thing to start with. But better contractual agreements are needed in any sector. You have to have better contracts with data processors to start with. You need to have data mapping exercises. You need to be good at sensitization. I think that's a very important thing. Like a post went viral featuring a newspaper vertical of Vistara, or maybe Tata Airlines, Air India, featuring that, they now have a data protection officer and everything, and their specific address. You can contact us for data protection concerns, which actually people were happy to see that, because that's the beginning. Right now you actually have a data protection officer and everything, and now you are going through. So that's a good thing to see. Um Now, this is the case study. I'll be quick with this, and this will be a little fun to discuss. So in this case study, I have named it Indori Kirana. So if you are from MP or UP, you'll find this name fun. So basically, Indori Kirana is actually good at delivering groceries. Basically, a departmental store in an e-commerce form, giving away, grocery items in the city. And when that's happening, as a company expand its operations and customer base, there are certain challenges. So let's understand those challenges, and I think we can address those questions based on what you require. So the first question is, even for a departmental store, what could be about how should they ensure that they know about the flow of personal data if they're using certain third-party apps or certain things, or whatever adjustments they're using technologically, should they know about it? What's the major concern around it? Then should they identify all third-party data processes, as I said, because that's a very crucial thing for e-commerce. Because you may run ads, you may have certain uh, uh, other adjustments so that your website becomes handy. So in e-commerce, that's obvious to see, which is why. And definitely you need to have contracts in e-commerce. You need to have end user agreements or data transmission agreements or transfer agreements. You need to have those things, because that will be a lot helpful for you. And therefore, you should also ask if your consent management system is transparent enough, and whether you are giving clear and concise information. Once I think a bunch of customers also become aware, then I think it becomes easier for you to have a collaborative sense. So these are also an important aspect. You have these questions yourself. You can ask me in the context when in the Q&A happens. I can share the deck later for sure, with readings. uh, so that was e-commerce. And there's certain other things which you can also see, like minimum amount of personal data needed to be processed, how to ensure that personal data is used for the way it is. It's repetitive, as I said in the very beginning. A lot of it is repetitive to start with, but I'm trying to make it simpler to understand, to see, because these will happen in the day-to-day transactions. These are basic things, and when more rules will come up, it will become even more specific. So that is for a governance perspective. Now, in fintech, I'll be very specific, since we have discussed consent and contracts too many times. In fintech also, the same dilemma happens, whether you have platforms in stocks or payment apps or anything. Affiliate marketing and a lot of things are actually relying on this, right? Get the right data, do certain things, and that's fine. You have certain agreements. So even there, you have to make it clear why, a bank or a fintech app has to make it clear why a customer is going through certain things that a customer is seeing. So consent matters, right? Uh, that's the important thing. Uh, then you have data minimization. Same thing happens, but the good part with fintech is I can tell you there are certain established practices in the fintech industry because of the RBI, because the fintech industry is not typically expected to be too innovative. It just has to do what it is required to do. The threshold to be a fintech company is already very high. So obviously, the chances are least that, what, you just can have anyone scamming around just coming up and making a fintech entity. So in fintech, obviously the threshold is high for a reason, and that's good in certain ways. And that's why minimization techniques and all these things matter. But we already have some very interesting sector specific understandings under the NPCI and the RBI. So I think, in my understanding, what will happen is that the Reserve Bank of India's regulations, the fintech regulations, will be above the DPDPA. And for certain things where we don't know, the DPDPA will be like the Indian Constitution of data protection, like a basic law of understanding. You can reflect that in your contracts as well, and that works out, right? So that your merchants or your entities can be helped properly. Now, this is what exactly I was talking about, which was conflicting and overlapping requirements, that there will be certain aspect of financial data. So I'll definitely share the deck. Uh, these are the key takeaways you can look through, uh, uh, which is about data minimization around aspects of KYC. Now, it's a quick case study for another startup or company. Now, I have named it Dhan Sanchar. So let us say that Dhan Sanchar is offering certain work when it comes to financial management, personalized investment advice. They are directly under RBI and SEBI in certain ways. Uh, what are the potential conflicts which it will face? And as I said, there will be a lot of regulations. There are a lot of guidelines and understandings and circulars which are already above the DPDPA. So even before the DPDPA is implemented, a lot of fintech companies and stock companies are actually going to adhere with SEBI guidelines and RBI guidelines. But there will be some gray area always. How will you deal with that? And when it comes to AI specifically, beyond processing issues, uh, uh, how will we ensure that the AI which is processing through is kind of aligning with certain practices which are genuine enough, which are privacy compliant, because of the uncertainty part? So I think it's also about the scale of the AI model in certain ways, how much you are expecting, what are the iterations. I think in fintech that could be a possibility to work around. When it comes to credit scores and other things, it's a different dilemma altogether. There are already established understandings in under SEBI and others, so I'm not getting into that. So that's about Dhansanchar, but you can actually, because these questions are not something like which can be exactly answered, because again it depends on your model, but these are self-reflective questions, so that you are aware as to what exactly could be happening. So that's why I put these questions, and yeah, that's the thing. uh, Now when it comes to healthcare, I'll be quick so that we get into legal tech. uh, in healthcare, the one thing which we need to see is uh, uh, a lot of information will be sensitive, and a lot of sensitive information will be transacted through collaboration between research companies, hospitals, and other third party entities. Is very interesting to see how it will work. uh, because as I told you, it's being thought out whether you can have anonymized data from our countries, bring it to India, and ensure that it is not de-anonymized. So all AI and law issues start with data protection issues, but as your models evolve, and it's just a business model and compliance models evolve, a lot of will transform into AI related legal issues. So the same applies in health. What kind of data you're taking, and therefore security audits are necessary. I think in health it will be more stringent, simply because uh, the risk of leaking health records or the risk of leaking other sensitive information is huge. So, of course, stringency will be there. Uh, then we explainability and AI when it comes to that in health. Of course, uh, that is very important to be dealt with, because if you are providing certain diagnostic recommendations, how have you done that? That is pretty much required to be done, because if you're automating certain processes and ensuring that a customer is given certain advice which can work in a short-term basis. Why are you doing it, and is your model reliable enough? Because even I've been through startups who are in the mental health space, who are trying to build their LLMs, who can provide certain advice on fatigue, depression, and other forms of mental health problems. Well, to say mental fatigue, sorry, not physical fatigue, mental fatigue. So they say that their accuracy is around 82% or something like that, which is fine. But again, they would have to deal with that. How is the pilot testing going on? Whether it will be safe. I think a lot of it is in nascency also, right? A lot of AI systems are in nascency in India when it comes to their commercialization, except maybe the bigger players. So I think that is something from an explainability point of view. And the same applies to data minimization in the context of health. And that is something I've already discussed. But yeah, when it comes to patients in a hospital, uh, if you are repurposing their data, you need to have a sense of new consent, because patients can be discharged and you still have the data retained for a period of time. You can retain it for whatever time you have, but even if you're retaining it, you need to have consent as to why will you process it. And sadly speaking, in health tech, that's not being done widely properly, and that is an issue for an end user. Even for startups who might do research in this, for example, there might be space tech startups who might do some R&D work to develop drugs. They might also need certain data, so contractual agreements matter a lot. uh, this is something which is an interesting issue, algorithmic fairness, but I'll be very quick on this. You can see the points. uh, they will matter in crucial aspects. For example, there are specific diseases or specific illnesses, and you need a stakeholder engagement at a local level, at a state level, at a city level, let us say district level. Then will you incorporate that? Yes, because healthcare is a very sensitive industry. The same would happen in education. For example, you hire companies who are offering, you know, uh, Gen AI chatbots who are helping a student understand basics of, basics of kinetics or something like that, or algebra for the class 8, curriculum, or class ninth curriculum. And you want to ensure that a child is getting accurate understanding, because sometimes a teacher does not have time, so you have certain use cases like chatbots and all that. But are you doing it in a way that it's not misinforming the child or harming the child? Because that's also a use case of GPT for Omni by OpenAI. That's, and Khan Academy has actually kind of partnered with them, which is an interesting thing to look forward to. So that's about algorithmic fairness, and these are the key takeaways. uh, yeah, basic things, I think. That's there. uh, since I think we have to focus on Q&A quickly, because I know people might be leaving and time issues might be there. This is a case study, which is again about the same thing, about sensitive health data and obtaining explicit consent post discharge and all that. Now let's talk about legal tech quickly. So a lot of legal tech in India, you can partner with law firms and chambers, but legal tech might also be useful for a lot of people who are not in law. For example, a lot of people who have to do basic compliances and basic contract signing every single month. And it could happen even in supply chain management, it could happen in transportation industry, right, where certain permits have to be given, certain consent agreements have to be done. So a lot of contractual work in legal tech also is mattering. But the problem is, uh, for lawyers and even companies, the problem is they have a lot of proprietary information in these contracts, and their fear is that all these AI models, should they just process all of this data, and how can we ensure that it's gonna be safe? Because spilling of personal information in contracts actually has been a problem with OpenAI, and that could happen with AI, any AI model, if they are not fine tuned properly. So intellectual property and trade secret issues happen, which is why the legitimate use requirement in DPDPA is given for corporate espionage and trade secret and all those issues. That's a basic thing, right? So that's why it's a basic law. But if you need further clarification on this, I think more rules will come from the government side, and we'll see how it goes. So that's the one thing. Second is obviously explainability. If you're processing something for your clients or for your vendors in legal tech, like contracts or other things, or even you're recording certain, so even life cycle management happens for certain processes to show that you're compliant in a factory or anywhere. How are you doing it? Are you doing it in a way that is explainable? So that's a dilemma which of course applies with AI models. uh, I remember a case study where SAP kind of did this in Germany, where they used predictive modeling, visual, like in CCTV cameras, to detect how their workers are actually, doing efficient tasks. That happened in supply chain management and other things. From an HR perspective, it's also interesting. Is it invasive to privacy? Yeah, it could be. But yeah, that's something which they're trying to do maybe in India. That's the thing they have tried to pitch. So they are a case study, and Amazon definitely is a case study how they're doing it. A very interesting media report also came in on how it's happening in London also when it comes to facial recognition and efficiency testing and all that, which is basic HRM practice for who's somebody who's using AI. So yeah, this is this, and these are the key takeaways. I've already said one point. I'll just quickly come because I think I've already taken up too much time. But which is about granular data access controls. That will matter, I think, in all these sectors, and I think that will evolve for companies right now because even they have to come up with business models which are sustainable. And that's a very important dilemma for companies, and I understand that, and I think eventually, I think that can be understood as a norm even for governments to come. So that is something which applies to all industries in many ways. These are basic things about retention policy, so I'll not repeat it. And I'll share the deck. You can read about lawsamjao.in. I hope this is not a domain bought by somebody yet. Uh, that because yeah. So there's an AI-powered document classification and life cycle of a contract. It can expire or not. How will you manage it? So that's the dilemma. So these are the conclusions, as you can see. And I think this will be much informative for you. I'm sorry I tried to pack it up, but I think it took most of the time. But I think if Ayushi is fine, and I think you are fine, I think we can have 5 to 10 minutes for Q&A. What do you think?
Sure.
I think yeah. I think so.
Cool. I think, guys, you can start posting questions in the
So
chat.
I think yeah.
Abhivadan,
So these are the conclusions, especially about the contract part. Yeah.
yeah, Abhivadan, just one thing. I think most of the people that I hear on the call, right, they just have two ways to use generative AI right now. Hello, am I audible? Hello.
Yes.
Yeah.
You seem audible. Yeah. Yeah.
Yeah.
Yeah. Yeah.
So I'm
Yeah.
saying, all the people here on the call, right? Right now, there are two major ways to use AI, right? Either I can use, say, OpenAI or Anthropic or some other models, right? Or I'll just fine tune my own models. Does How does this law change? For example, if I'm using OpenAI models, right? But I would not have taken explicit consent from my customers, right? All the data that I have right now, I would not have taken any consent regarding ki I'll be passing your data to OpenAI, or I'll be fine tuning the model, or I'll be fine tuning it myself, right? So in first case, third party is involved. Second case, I'm fine tuning it myself. How does the law impact these use cases? Because this will be the majority use case that startups will face. And how do I take
Yeah.
consent? I think that will come after that. But yeah, how do I take consent? How do I bundle it? Because there'll be thousands of things that I can take consent for, right? For example, I can use login information, the behavior patterns, but how do I take it in a bundle? And after that, we can figure out how do we delete it. But yeah, please.
Right. So with third party, so there's a thing concept called garbage in, garbage out.
Right.
So you process original data, it goes into OpenAI models. Synthetic content is processed, which is to say output, right? Basic prompt engineering, plus fine tuning and other things. Now, the problem is when you have third party models, at the level of integrating those things, I think it is up to the people in the technology team to ensure that they are controlling the way OpenAI is processing certain things. And it's also a hallucination thing and other things that you need to ensure that intrusive details are not taken, yet the efficiency of the deliverable is not effective. Affected. Sorry. So I think that's the way we should take it up, because again, it's a trade secret plus copyright issue. Even for OpenAI, it's very hard to deal with. They have some app store or something they tried to launch. So I think it's a very it's like a fait accompli. So yeah.
So from DPDPA perspective, do I need to ask, like take explicit consent from my customers that I'll be passing your data to say OpenAI or any third party, or
Yeah, I think yes, but I think if it is clearly specified as to what limited data will be processed, and you are also aware that you're not giving that much to OpenAI, then I think it's fine.
then
Which
it's
again
okay.
is practice based. It depends, but I think it's possible. Yeah.
Understood. And you also talked about the right to erase, right? I think, for example, if I've trained a model, right,
Hmm.
and I've used your data, and you come back to me saying, "It just delete my data," and it's not possible to delete that data from the training set, right? From the final model, right? Because that's not directly used, but that's indirectly used. How will a startup typically handle that scenario?
Well, when you have training data and you have to ensure that you delete it, again, if you're talking about third party models, again, the biggest problem which even OpenAI and others are facing is you're processing all this data, but even if you do machine and learning, so there's a report from the Seoul AI Summit, and that's a internationally acclaimed scientific study. It's not a policy study or a legal study. Widely, the problem is even till now, even if you do machine and learning and ensure that your systems are being deprived of that data, the way an algorithm learns, the quality of the synthetic content itself goes down. So yes, it might work theoretically, but there will be certain bits and pieces in a fragmented manner of data which will anyhow be processed, and it's like something will be processed even if you filter out the data and in the process. So it's a very tricky dilemma, because no matter how much capacity you have for processing, you need to be very specific about what data is going inside even from the beginning, so that you have certain. So there are two kinds of licenses also, GPL and PSD, and that's what we have also tried to address in a report in our firm, which is, we call it uh, uh, open source AI practices. How to do that? We have addressed these issues about general purpose and basic standard. Yeah.
I think take up some questions of the chat also. One of the questions is, at what stage should a startup be worried about this policy? And do you think in the initial stages, people need to worry about this? So, for example, if they're just starting an AI company, right, do they need to worry about these policies, taking explicit consent and going into those details and all those sort of things? Or can they ignore it for some time and then focus on it, right, once they scale? What do you think?
No, I would say that until the rules come in, and I don't know when will they come, uh, you should not worry. You should rather be alert in a way that at least you come up with some basic practices. So IAPP and other organizations which actually work on aspects of privacy ethics, they actually have certain practices. And if you already decide at the level of incubating some idea or something or any operation or project, I think it's better, because if any adjustments would be done or something new would be coming, reverse engineering anything would not be possible at a moment, because certain models are created, certain work systems are created, certain knowledge management practices are created, and for startups and MSMEs it's a lot messy territory, right? You have your own work cultures and things, so of course managing data and all that becomes messy. So it's better from the beginning not to worry, but at least understand what could work out and how much are you doing, and reveal in a way which is reasonable. And I think it can work out. If you want to go open source, your choice. If you want to keep it proprietary, no problem, keep it proprietary. But I think start from the beginning, not worry. Doesn't work, but yeah, be alert about it. Yeah.
Understood. The next question is, how will this affect B2B or B2C startups or B2B2C startups? Any
it will
bit-
aff- it will affect
concern?
any startup. It depends on the end user itself. It could be a business user or end user. It doesn't matter. For example, the digital competition bill, if you read section 3, it gives you a threshold of how many end users and business users you need, so that you have to be apply with certain thresholds, and you don't have compliance issues, and you are also not anti-competitive causing market capture. So I think it applies to all. In B2C, the difference is about consumer regulations. For example, how a consumer is interacting. Are you providing invasive patterns? Again, it boils down to business model, but it will apply to all. It's not like specific to business or consumer specific.
Understood. Understood. Folks, I think if you have any questions, please you can type on the chat or you can raise your hand, right? I think someone has just asked, patient scenario, hospital IT team will be uploading data to a health tech website. Uh, in such a scenario, the website has to assume the patient data is owned by the hospital IT team. Since they cannot get explicit consent, I think this is the exact same question that we were talking about, right? How do you handle the situation when there is a third party involved?
Right. In such a scenario, that health tech, that platform has to assume that patient data is owned, and since they can't get explicit consent, the consent can be from the IT team. Then uh, I think, uh, I think then at least if consent is not easy to be gathered, then at least for a legitimate purpose you have to process, and yes, you have to get it from the relevant IT team. But then again, certain transparency is necessary to say that, you know what, uh, you're doing it in an ethical way, in a safe way. But the best practice is keep it as a backup or maybe an option, so that somebody who has already been discharged from the hospital or is not availing the services of the hospital is actually knowing where my data is going. There has to be an option to communicate and ensuring that sense of, because again, uh, uh, you know, it could be possible that due to lack of awareness people can, enable not using certain things, but and ignore it. But again, the concern is severe because a lot of these decisions around diagnostics and health records, they actually affect a lot of health tech products and solutions. So if consent is not taken, obviously it's a problem, but it's also a fait accompli. So at least keep a backup option so that somebody can get back to you and you can have a proper coordination. And yes, you have to take it from the IT team with consent, but then you have to be very specific about it.
I think, guys, you can ask questions.
Yeah, any questions in the chat? And if there are very technical questions, very specific questions which are not that broad but too specific, you can definitely connect with me on email. I can just share my email on the chat. And this deck will be shared by the organizers. I'll ensure that they get the PDF. So you can also connect with me at connect@abhivardhan.com. You can also connect at us at indicpacific.com. That's not a problem. Because again, I know that a lot of people might have found a lot of this repetitive. And the very reason is that, again, it's under development and a lot of things depend. But I've tried to make it simpler and fun for you to understand. And yeah, I hope the references are a bit helpful.
Guys, any other questions? I think we are good, everyone. I think thanks a lot for I think sharing the details and helping us with this. Let me just share. Just give me a second. Yeah, I think thanks a lot everyone for joining in. I think these are the details. You can reach out to Abhivardhan at contact@abhivardhan.com, or you can also visit his email, like website, right, to know more about what the work he's doing, the documents he's publishing. And Abhivardhan, I think if possible, we'll also share the documents that you've talked about, right? For example, you mentioned some research your company has already done, right? We'll also send that to all the people along with the PPT.
Open source. Yeah. Open source licensing. Yeah, sure. I'll share the link. No problem. Share the link.
Sure. And guys, if you want to join the WhatsApp group, if you haven't already joined, you can scan this QR code to join the group. And I think thank you so much for this, Abhivardhan. I think it was really nice talking to you and knowing about the AI like policies landscape. And let's hope for the best. And let's see whenever the law is going to be released. So, yeah.